here for 10 years. After about 10 years working in big law firms in DC. Most of what I do is biotech patent law. I have a graduate degree in molecular biology. And right now, you know, for the university, I'm advising them on all the patent issues for all the inventions that are disclosed on the biotech side. We also have a biomedical engineer and who does a lot of medical device and software work. And we also have a PhD chemist, a patent attorney. So today, we're going to go through, here's where we're headed today. We're going to talk about patents and how they fit within the larger term that is intellectual property. We're going to talk about the rights that you get when you own a patent and what you can do with that patent. We're going to do a review of a sample patent that I think Carrie sent around to everybody, where we're going to look at patent claims, and I'll explain what patent claims are. We'll talk about the patentability requirements, as well as patent application disclosure requirements. We will talk about patent infringement and what that means, and how you analyze patents for infringement. We're actually going to go through a patent claim drafting exercise as well. And I'm pretty sure, based on time, because I've given this presentation many times over the last 10 years, that we'll probably end with the public disclosure discussion, but you never know. I will send this presentation over to Carrie after we're finished, and if you guys would like it, I'm sure she can send it along to you. My contact information can be found on the website as well. If you have any follow-up questions, I'll be happy to talk to you. Okay. It's a little slow to advance the slide. Okay, here we go. So types of intellectual property. Patents, trademarks, copyrights, and trade secrets are all types of intellectual property. Patents have a 20-year term. They are geographical in nature, so a U.S. patent is really only enforceable in the U.S., and you can file for patent protection in other countries on a country-by-country basis. And there are regional patents, like European patents, that are available. Patents protect ideas or inventions that could take the shape of methods or processes, compositions, or devices. Devices, from my perspective, are medical devices, but it could be like the sample patent that I sent you guys, a needle. It could be, you know, a barbecue tool or something that somebody invented in their garage. When I use the word compositions, that is technically a device, but from my perspective, those usually refer to drugs or antibodies, things. Trademarks protect brands, names, and slogans, and they're basically source identifiers. If you see the golden arches of McDonald's, you know what those French fries are going to taste like, right? They don't taste like any other fries you've ever had. The Coke tastes a certain way. In fact, one of my best friends from law school is a Georgia Tech engineer, and her sister is a Coke engineer. And I found out that McDonald's has their very own brand of Coke that doesn't taste like any other Coke that is sold. And as long as you use those trademarks in commerce, selling goods and services associated with the trademarks, then they could last forever. Copyrights protect expressions of ideas. If we were all to write something about, say, an international spy, each one of those works of authorship would be protectable by copyright, whether it's a short story, a novel, a movie script, a poem. And as you can see from the bullet point, that the term of the copyright is listed there. Trade secrets are things that give a company a competitive advantage. It could be a recipe for Kentucky Fried Chicken. It could be a recipe for Coke. Krispy Kreme, Twinkies. It could be the Google search algorithm. And as long as the company keeps that information secret, then it could potentially last forever. Okay, now let's start talking about patents. So what rights are we talking about, and what does a patent provide the owner? Most people don't know this, but a patent provides the owner with the right to exclude others from practicing the patented invention. And by practicing, I mean making, using, selling, importing the invention. And the right to exclude as opposed to the right to practice your invention. And the next slide will show an example of what that means. But in terms of a license agreement, a patent owner can grant one, some, or all of those rights to a licensee, usually in exchange for money, right? So if I have a patent on a drug, but Brian Stansky is a big manufacturer, I could enter into a manufacturing agreement with Brian to make my drug, but I would have to grant him the right to make the drug in exchange for money. And another way of looking at it in terms of exclusion is I promise not to exclude Brian from making the drug. And that promise or that license really is a promise not to sue somebody. Okay. So that's an important distinction of what a patent provides you. Now, I said before, right to exclude as opposed to the right to practice your invention. And again, I've listed what practicing the invention means. So here's an example that helps you understand the difference. So consider the following. Let's say a company, Pfizer, for example, has a patent claim for a composition comprising and insert the structural formula of a drug. Okay, and let's say that drug is used to treat hypertension. Okay, but then I come along, I'm a doctor, and I notice that all of my male patients, all of my bald or balding male patients, as they're taking this drug for hypertension, their hair grows back. Okay, so I, because of this awesome presentation, started filing a patent application for a method for growing hair comprising the step of administering the drug. And I get an issued patent. Okay, but that does not mean I have the right to practice that invention. Okay, I cannot practice that invention, the hair growing patent, without a license from the owner of the drug. Okay, so again, right to exclude, not the right to practice your invention. Okay, so now I'm going to switch gears. I'm going to show you this slide, and we're going to look at the sample patent, the needle patent, that I hope everyone has. We're going to talk about terminology, and while we're looking through this, we're going to talk about the parts of a patent or a patent application. And then really we're looking at this so I can show you what claims look like and how to understand claims and differentiate between the claims. So I'm going to stop sharing this presentation for a second and then move to the needle patent. Here it is. Okay. So here's the front page of our patent, and I'm going to show you this part really quick. So if you look at patents online on Google Patents or the Patent and Trademark Office website, you'll see an internet HTML version of it. This is the real version, what we call the dual column format, which you can download from Google Patents, but they're not usually searchable. Okay, so on the front page of the needle patent, there's a couple of things worth noting. This says United States patent. This is an issued patent as opposed to a published patent application. So patent applications are published. Here's the patent number. This is the 6,189,747th patent issued in the history of the Patent Office, which is roughly 230 years. Okay, I think I don't know, we might be at 11 million right now, issued patents. Here's another, actually, let me go back. Here are the inventors, probably a husband and wife. And if you're referring to issued patents, the way we refer to these things is by the patent number, and we would say the 747 patent. We wouldn't say the Collingham patent because they could have 10 or 20 patents. So it's the 747 patent. If we're talking about a patent application that hasn't issued as a patent, we look at this number here, the application number, and would refer to it as the 884 application. Okay, and so throughout this presentation, I'm going to talk about terminology because I want you to be able to speak the language, right? To use the right terms. So this application is the 9,481,884th application ever filed. This 09 number, the 9 million number, is what's called a series number, and this is just for your own edification. Right now, we are at 16 series. So there have been over 16 million patent applications filed in 230 years. I'm going to make this a little smaller so that we can look at each page quickly. In this device patent, or if we're looking at a patent application, the figures are very important, right? That's the best way to convey what devices look like, right? And you'll see, and we'll get to the reason why these little numbers are here. And then we get to the body of the patent application. The background of the invention just describes the problem to be solved, right? Or, you know, it'll generally say, here's everything that came before us and why it isn't very good and why our invention is better. There's a summary of the invention. There are the brief description of the drawings. And then we get to this part here, the description of the preferred embodiment. In my biotech world, we call it the detailed description of the invention. But here for device applications and device patents is where all those little numbers from the figures come in. Okay, so in this line here, it says hand sewing needle 10, which has an elongate body 20, which has a first end 30 and a second end 40. So if we go back to any figure, right, 10 is the needle, 20 is the elongate body, 30 is the first end, and 40 is the second end. Okay, that's why those numbers are there, which it makes it helpful to refer back to the figures and understand the parts of the device. And at the end of every patent, at the end of every published patent application, are the patent claims. Okay, so these are probably the most important thing you're going to look at when you're studying these things. These are what define the invention. And to use a real estate phrase or term, it describes the metes and bounds of your invention. Now, each one of these numbered claims are actually just one sentence, okay? Everything in this patent except the claims is what we refer to as the specification. So there's another term, specification. So when you're talking with people and you're talking about claims, somebody might say, well, I wonder how the specification defines this term, right? How does it define solid structure? Okay, they might say spec instead of specification, and that's what that means. Everything in the document except the claims. Now I can stop sharing this and go back to the presentation. Here it is. Okay. So here I've reproduced the first claim. And I'll just read it through with you very quickly. A hand sewing needle comprising, and by the format of this claim, you can tell that there are two elements to the needle, right? An elongate body and an eyelet, okay? Now, the elongate body has certain characteristics. It has a first end and a second end. The elongate body is straight, having a single axis extending between said first end and said second end, which to me is somewhat redundant. That's what straight means. It has a single axis, but that's fine. And I'll point out this word here, said, or said first end. This is sort of an old way of writing patent claims. And if your patent attorney is an old person, then you're going to see patent claims that use this word. I know I haven't written like this in over 10 years. But the first time that you write first end, it'll be a first end. And every instance after that, it'll say said first end. Okay, old way of writing. But that it makes it look even more archaic in my mind. So straight, we have a solid structure. And then this part here says the first and second ends are pointed. And then the eyelet is somewhere along the elongate body between the first and second ends, right? So this text below, I've just reproduced the two elements and the structure and the characteristics of the elongate body and the eyelet. Okay, so this is the scope of this patent claim. Now, let's look at these other claims. Okay, now, as you'll notice, each one of these other claims refers to a previous claim. So claim 2 refers to claim 1. These types of claims that refer to other claims are called dependent claims. They depend from another claim. So by definition, claim 1 is always an independent claim, right? No other claim came before claim 1. So you'll notice there is no other reference to another claim. Now, the scope of a dependent claim includes all of the limitations of the claim from which it depends, and plus probably something else that's in the claim itself. So this claim 2, the hand sewing needle of claim 1, wherein the eyelet is positioned at a center point of the elongate body. So that just means the eyelet is in the middle. Okay, so if you remember the first claim, the eyelet was somewhere between the first and second end. So it could be in the middle, it could be one end, or it could be near one end. Claim 2 is more narrow. It's saying, well, it's in the middle. Okay, now look at claim 3. That depends on claim 2, and now it's specifying that the eyelet is oval shaped. Okay, but claim 1 just says it's an eyelet. It could be any shape. Okay, so now you're starting to see the different scopes. And again, dependent claims always narrow the claim from which it depends. And in this case, it's specifying the eyelet as oval shaped in claim 3, but a dependent claim could add another element, which then makes the first claim more narrow. It's adding elements. These other ones are interesting. I think this 8th claim here is interesting because it says the first end and the second end are tapered. So if we look back at the first claim, it says the elongate body, the ends are pointed. And then this dependent claim says the ends are tapered, but I can't think of something being pointed without being tapered, right? So that claim is a little strange. But again, the purpose of this is to show you independent claims, dependent claims, how dependent claims can help you understand what independent claims mean. It can help you understand the scope of the invention. And what's also important here, and I'll use the terminology, the spec or the specification, can help you define what terms mean. Right, and I'm pointing specifically to claim 1 where it said that the elongate body was a solid structure, right? Solid, of course, it means solid, but a patent attorney might think, well, okay, well, does that cover hollow needles, right? It might not cover hollow needles. So then you look through the spec and you find this underlined sentence, the elongate body 20 may be solid in structure or may be comprised of a hollow structure. So because the term solid structure was used in the issued patent claim, to me that means it doesn't cover hollow needles. Okay, so if I was a competitor and I was reading this issued patent, reading the spec, I'd figure out that that claim does not cover hollow needles. And if I made hollow needles, then I wouldn't be infringing this patent. I wouldn't need to get a license from them. Okay, and that's good. And we do these sorts of analyses all the time. But from a commercialization perspective, maybe it's more expensive to make hollow needles, right? Maybe it's 10 times more expensive to make a hollow needle, which means your hollow needle will be a lot more expensive than the regular needle. And there's no indication that a hollow needle would perform better than a regular needle. So you may be able to circumvent this patent. You may be able to get your own patent. I don't know. But probably no one's going to buy your hollow needles because it's more expensive and it doesn't give any advantage by using the hollow needle. Right, so the scope of Claim 1 covers only solid structures. And I think this is the last slide for the needle patent, but it's really just to show you that you could have a series of overlapping claims. So this Claim 9 is an independent claim. And I've simply underlined what's different between Claim 9 and Claim 1. Okay, and then I've reproduced the elements and the characteristics of each element below for Claim 1. But Claim 9 mentions a center point. It mentions that the eyelet is about the center point, so it's kind of in the middle. And then it introduces this element that the eyelet has an outer perimeter that's a little bit wider than the width of the elongate body. Okay, so a little different than the first claim. Somewhat similar, but it's a different scope, right? It's adding some other information. So as you go through each one of those claims, you could probably figure that out. So that's it for the sample needle patent. And I will say this, because I'm sharing my screen, it's kind of hard for me to see whether there are chats in there. So Gary or Brian, speak up if you see a chat that's relevant to what I'm talking about. I have to hover over something for me to see the chat.
Will do. I'll keep you updated.
Thank you. So now we get into the requirements for patentability. It's a lot easier to have a discussion when we're in person, and I usually ask this question of people if they knew what the requirements are for patentability. But I'll just go ahead and show you. 3 requirements. The first one, which you might not have heard of, is utility. Okay, your invention has to be useful. No kidding. And typically this provision, this requirement isn't a huge hurdle. But in recent years, if you're talking about diagnostic inventions, if you're talking about software inventions, utility is becoming a bigger hurdle for those inventors. The utility has to be specific, credible, and substantial. The second requirement for patentability is novelty. Okay, your invention has to be new. The same thing couldn't have existed prior to your invention. Okay, so when you file a patent application, eventually it'll be assigned to a patent examiner who's going to search the prior art and look to see if your claimed invention is novel. Okay, and by prior art, I mean everything that was published before the date of your filing, for the most part, before your filing date. And that's issued patents, that's published patent applications, that's scientific journal articles, that's product inserts for software, for devices, etc. Anything that was published, it could be some statements from people on a blog. Okay, search the prior art. And again, the test for novelty, okay, is the examiner is comparing your claimed invention is comparing a piece of prior art to your claimed invention. If that single piece of prior art teaches each and every element of your claimed invention, then your claimed invention is not novel, okay? In other words, the prior art reference is said to anticipate your claimed invention, and you'll get rejected. Okay. The last requirement is non-obviousness, okay? there may not be a novelty problem. In other words, there's not a single prior art reference that teaches each and every element. But a patent examiner could combine two references, which together teach or suggest your claimed invention. Okay, now I've taught law school before many times. I've taught patent law. I could probably spend an entire month going over obviousness and novelty and going through all the different cases out there. For our purposes, I'm just going to leave it with utility, novelty, non-obviousness are the three requirements for patentability. And you'll notice in this slide that I have in parentheses referred to the statute, okay, for each one of these requirements. This is Title 35 of the United States Code, sections 101, 102, and 103. The United States Code, those are federal statutes. Title 35 is just patents. You know, there's titles for the Internal Revenue Code, for copyrights, etc., for firearms. And so again, from a terminology perspective, people that you would be talking to may refer to novelty issues, may refer to anticipation issues, may refer to it as a 102 issue. It's all the same thing, okay? It may refer to an obviousness issue, which is the same thing as a 103 issue, right? A 103 problem, okay? So there's more terminology for you. Now, the tests for novelty and the test for infringement is basically the same, okay? Again, a single prior art reference teaches each and every element of the claimed invention. It's a comparison between the two, okay? Patent infringement is basically the same thing. It's just you're comparing the issued patent, you're comparing the accused device, the potentially infringing device, to an issued patent claim. And if the accused device meets each and every element of the patent claim, you have infringement. It's called the all elements rule. It's basically the same test as anticipation, just a little bit later in time. I have a little infographic to show you. And I'm referring to the central dogma of molecular biology. DNA begets RNA begets protein. And here's my central dogma of patent law. Okay, so if this line ran straight down, we would look at this left side of the infographic talking about a patent application, claimed invention in a patent application. And if a prior art reference teaches each and every element of the claimed invention in the patent application, then the claimed invention is not novel. The prior art reference anticipates the claimed invention. This side of the infographic is talking about an issued patent, so issued claims. And you compare the accused device back to the patent claim. And if the accused device meets each and every element of the claimed invention, then it infringes. Okay? Now let's talk about infringement. Let's talk about enforcement and a term that you may have heard called freedom to operate. And let's say we have this scenario where your company is developing a product and you don't have a patent application filed yet. Okay, you should be thinking about whether your product, let's say you have a prototype, does it infringe anyone else's patent? Okay, if so, we might need a license. That's also called freedom to operate. Do we have freedom to operate? Do we have freedom to commercialize our product and not get entangled in someone else's patent, probably our competitors? If so, can we design around any troublesome patents so our product does not fall within the scope of those patent claims? The other way to look at this that is necessary, it's a different sort of lens that you need to look at, is our product patentable, right? Knowing the three requirements for patentability: utility, novelty, and non-obviousness. You'd have to look at the prior art as well. So you'd have to look at your competitors' IP, and then you'd have to look at the prior art in general, which would include their IP, to figure out whether your product is patentable or not. And let's say that your company has a product that is covered by an issued patent. So you should think about, do any of the products of our competitors infringe our patent? So now we're talking about enforcement. And again, you should also think about whether your product infringes anyone else's patent. Okay, so infringement, freedom to operate, enforcement, patentability. These are all the things that you need to think about. They're just different lenses that you need to look through when you're developing products. Now, there are requirements under the patent statute, and I refer to this in the second slide, and I called it disclosure requirements. So there's certain things that need to be in your patent application that the patent office will look at to see if you've complied with those requirements. Best mode. You have to disclose the best way of carrying out the invention as of the filing day. So if we file a patent application and a week later you figure out a better way to do it, a better way to carry out the invention, you don't need to go back and update it, okay? Just as of the filing day. And this usually isn't a big deal in terms of patent prosecution. How would an examiner ever know if you disclose the best mode or not? Okay, this is a big one here. This is called enablement. You have to describe your invention in such concise terms to enable one of ordinary skill in the art to make and use the invention. Okay, enablement. To one of ordinary skill in the art, right? So if we're talking about a medical device, you don't need to describe it so that my 14-year-old daughter would understand it. Just other people that are similar to your inventors, okay? Engineers, doctors. And the way that I usually describe the enablement requirement is with a Star Trek example, right? So I could write a patent application and file it and talk about the transporter, okay, and what it looks like, at least on TV, and what you can use it for to get from ship to the planet or ship to ship and to escape before another ship blows up. But really, I couldn't describe how to make one at all, right? So I would get rejected for any claims, right, for a transporter because I didn't enable it. I didn't teach anyone how to make one, okay? And the third disclosure requirement in your patent application is similar to enablement, but it is a separate requirement. It's called written description. You've got to describe your invention in such clear and concise terms to demonstrate to others that you possessed the invention. And again, like prior art discussions of obviousness and novelty, I could spend weeks in a law school classroom teaching you about what written description is and what enablement is. But for our purposes, there's 3 requirements that need to go into your patent application. And it all depends on what you're claiming. And I'll say this, examiners and litigants. So patent examiners in the patent office can reject your application based on utility, novelty, non-obviousness, as well as the disclosure requirements, written description, enablement, best mode. A defendant in a patent infringement lawsuit, you have a patent and you sued somebody, can attack your issued patent on the same things, except for best mode. There's a change in the law that you can't attack somebody for failure to disclose the best mode. That's why I underlined it. Okay, so when I talk about these requirements, you know, you can think about it both in terms of patent prosecution with examiners, but also from a litigation perspective. Okay, so now let's get into a patent claim drafting exercise. We've all seen patent claims. Maybe it's just to the needle, but you've seen it. And there were actually 3 parts to a patent claim: a preamble, a transitional phrase, and a body. And the best way to start off describing what the parts of the patent claim are, is to start with the transitional phrase. And the one that you're going to see most often is comprising, okay? And this has a particular meaning in patent law. It's what we call open-ended, okay? So the scope of the claim, if it's using the word comprising, allows for additional unrecited elements. Now let's say that I have an issued patent claim, and very simplified, a device comprising A, B, and C. So because I'm using comprising, the scope of the claim is open-ended. It allows for additional unrecited elements, right? So the scope of the claim is A, B, C, and anything else. Okay, so remember our infringement test, all element rule. Compare the accused device to the issued patent claim. Does it meet each and every element? Let's say the accused device has A, B, and C. Does this infringe? Well, yes, because it meets each and every element. It's got A, B, and C. Does a device that has A and B infringe? The answer is no, because it does not meet each and every element. It doesn't have C. Does a device that comprises A, B, C, and D infringe this claim? Absolutely yes, because comprising is used. So the scope of the claim is A, B, C, and anything else. In fact, the accused device could be A through Z, and it would still infringe. Okay, so you can see the benefit of using this phrase. We should always use this phrase when we're writing patent claims. But there are, let me back up for a second. Comprising is the modern word, right? Including means the same thing. Having means the same thing, but nobody ever writes like that. Comprising is the word. There is a transitional phrase consisting of, which is the opposite, okay? It's closed-ended, and the scope of the claim is the recited elements only. So if we have an issued patent claim, a device consisting of A, B, and C, the scope of this claim for infringement purposes is A, B, C, and that's it, nothing more. A, B, and C only. So what infringes? This claim infringes because it meets each and every element. This claim does not infringe because it doesn't have C, doesn't meet each and every element. This claim does not infringe because the issued patent claim, it uses consisting of as a transitional phrase. So the scope, as we said, is A, B, and C, and that's it. And therefore, A through Z would not infringe. So you can see how narrow this claim is and why we probably shouldn't ever write claims using this transitional phrase. And yet, people still do. Now, the preamble, and you'll see why I started with the transitional phrase in a second. The preamble is everything to the left of the transitional phrase. So in our sample patent, I believe the preamble was a hand sewing needle, okay, and then comprising. A lot of times people will ask, and this will happen in litigation when you're trying to figure out what the required elements or steps are of a claim, is the preamble a limitation that you need to meet in order to infringe, right? And like many legal tests, it's a nice, amorphous test. Does the preamble breathe life and meaning into the claim? And this is the example that I usually use. Let's say we had our original claim and it was a method comprising taking drug X, right? So a very broad method. You take a drug, the claim doesn't say why you took the drug. And let's say that while we were prosecuting this claim, the examiner found a piece of prior art talking about drug X for treating headaches. Okay, and then I amended my claim. I changed my claim and I got it issued, and I changed it to a method for treating cancer comprising taking drug X. Well, I made that amendment to get around the prior art, again, which taught headaches for drug X. The scope of this claim, I would argue, is you got to take the drug for treating cancer. Okay, so in this example, the preamble is a limitation. Okay, but a lot of people like a preamble because it kind of introduces what the claim means, right? A method for treating cancer. Okay, I know what this is about, right? A hand sewing needle, etc. The body is easy. Everything to the right of the transitional phrase. Okay, so it'll be A, B, and C. It'll be an elongate body and an eyelet, etc. And that's it. Transitional phrase, preamble, body. Now you're ready to draft. I see you, Jen. Now you're ready to draft the claim. Why don't you unmute yourself, Jen, and ask your question?
Yeah, so my question is about the drug X. So what if the pharmaceutical company has a patent on just the composition of the drug, but they don't say what the drug is for, right? So I don't know what the preamble would be, but that happens a lot, right? Where they have a patent on the actual composition of a small molecule. Doesn't matter what you use it for, it's their small molecule, right?
That's exactly right. Okay, so for that example, it would probably read a composition comprising, right? So you're right. It doesn't matter what you use it for. If the entire application talked about cancer, okay, and then someone else, this is like the hair growing example, which by the way was a real example. That was Rogaine or minoxidil. That's what really happened. If the entire application or patent talked about treating cancer with these drugs, but then somebody figured out you could treat hypertension with the drug too, you know, that composition claim still covers what anybody else does with a drug because it's directed just to the drug. It doesn't say what it's used for. So I would probably never write a claim, a composition for treating cancer and then disclose the structure, right? I mean, you're probably narrowing it unnecessarily. Is that it? Does that answer your question?
Yeah, thank you.
Good. So let's go through our little exercise of drafting a patent claim. And we're going to draft a claim to this. And usually, again, I would probably ask somebody in the audience, but it's a little hard here, to draft a claim. And usually what I do is I ask, okay, well, what elements do you see here? Okay. And what are the parts of this chair that we can claim? Right. And obviously we would say this: a seat, 4 legs, and a back. Okay, because this is our commercial embodiment, and that's an easy way to draft your first claim, to get something on paper to look at is, well, here's our commercial embodiment. Let's just write that. So it's a device, and I didn't say it's a chair. I just said it's a device, right? You could stack books on it for all I care, right? I don't want to unnecessarily limit my device claim. It's a device comprising a seat, 4 legs, and a back. Okay, now, I said it before in terms of lenses. We've got to look at these claims in terms of patentability and infringement. Okay, so let's start with infringement. Okay, so think about the best way to describe this is, how would I not infringe this claim? How would I not meet each and every element if I was a competitor? Well, I guess technically I don't need a back, right? Because I could just make stools and not be covered by this claim. And technically, I don't necessarily need 4 legs. I could do 3 legs, and I could probably do 2 if they were wide enough. In fact, I could probably just do 1, right, and just call it a tree stump. But then there's the commercial reality of things, right? So infringement. You look at your claim and you think, okay, here's my commercial embodiment. Let's make my claim better. How do I not infringe? Or how is somebody going to design around my claim? Let me make it better. And then let me make it broader and therefore better. And then from a patentability perspective, if I start stripping away all of these elements, well, maybe I get ensnared by the prior art, right? So if I said, at least 1 leg, okay, an examiner is going to cite a tree stump against me or something like that, right? So you can strip down your claim too much that it's no longer patentable. It could be too narrow that no one's going to infringe it, right? So the way to look at your claim is just put something on paper, think about how do I design around it, and have I stripped it down too much so that it is not. So this is what we've come up with in the past. And we'll just say, okay, we need a back just for our example. A device comprising a seat, at least 3 legs, and a back. Okay, now we start thinking about other features of our chair that aren't necessary in the independent claim, but let's think about the different ways we want to make a chair maybe in the next 3 years, or, you know, maybe let's think about what other people might add to this chair. You could add arms, you could add wheels, cup holder. You could think about, what is it made of? Is it made of metal or mesh or a combination? You know, the back tilts, the seat swivels, etc. And then you start adding dependent claims, okay? Like this. And because this is a device claim, a device patent application, I would probably have figures or pictures of all these different embodiments, right? I probably have 30 different pictures of chairs. And now, as we write all of these claims, you'll see now a roadmap for what I need to put in my patent application to make sure best mode, written description, enablement, that sort of thing. And so when you first start writing patent applications, you know, people just say, well, you know, I'd start with the claims, and that'll provide a roadmap for how you write a patent application. And then, again, this is sort of this really overly simplified example of how to write a claim. My engineering colleague, Louisa, would say, you know, Guido, you probably have to talk about how the seat is connected to the forelegs in the back. Right now, they're all just sort of floating out there in space. A patent examiner is going to make you specify more because it's sort of indefinite. You don't talk about how they all sort of interact. And then that would be it for our patent claim drafting. But I really want to highlight, again, this patent analysis, and that you need to look at it from two different perspectives. Okay, from an infringement or freedom to operate perspective, again, let's say you're a company, you've got a prototype, and now you're looking at prior art, you're looking at your competitor's IP, and you should always start with the patent claims. Again, just like the analysis we did, the all elements rule. What are the required elements? Does our product meet each and every element? How is it different than the claims of this issued patent? How do I design around it? If I do meet each and every element, how do I design around it? And how does that affect the function of my product? Does it make it better? Does it make it worse? Do I really need a license? Am I really kind of covered here? And again, use the spec to understand meaning of claim terms. Am I looking at an issued patent or a pending application? An issued patent, those claims are, I would say, sort of set in stone, right? You can mostly figure out what the scope of those claims are, but a pending application may change over time, right? Those claims are always written broadly at first, and they become more narrow over time once the prior art is brought out. So if you find a pending application, keep track of it, because those claims are probably going to get narrowed. And then again, if you're in a company and you've identified, as you should, important patents that may affect your freedom to operate, now you know, well, okay, well, we may have certain positions of non-infringement that we're comfortable with, or we've done a really deep dive and we've figured out that there's prior art that creates a 102 problem for that patent, or maybe it's obvious, or maybe it's not enabled, etc. And then there's this unenforceable thing, right? So there's three ideas here: non-infringement, invalidity, meaning you didn't comply with one of those requirements, it's invalid. And then unenforceability, which is, it's otherwise a valid patent, but somehow you've behaved very badly in getting that patent, which makes it unenforceable. And really, this inequitable conduct thing is what we call fraud on the patent office. And the one example I'll give is there's a requirement that you have to disclose all the relevant prior art to the patent office. Okay, that's relevant to your claimed invention. But if you say you just intentionally withhold prior art, okay, that's fraud on the patent office. And in litigation, it would come out, and it could be held unenforceable for inequitable conduct, which is very bad. Okay, now patent analysis from a freedom to operate perspective, but also from a patentability perspective. So again, if we are a company, we've got a prototype, we search our competitors' IP, and we're looking at freedom to operate. Let's also look at patentability, right? So we've got our prototype. We can look at our competitors' patent claims first, but you have to worry about what the entire thing teaches or suggests, not just the claims. When you're thinking about patentability, you got to look at the whole document. Okay, is it really prior art? This is more a job for your patent attorney looking at filing dates, and is it really prior art? And understand that patents and published applications are much broader than journal articles. Okay, patent attorneys just broaden everything out. Okay, and they, you know, on a drug patent, they'll list every disease known to man and say, yeah, okay, you can treat everything with this. Okay, so if you're looking at prior art and it's a patent or published application, okay, it's going to be a little bit broad. Is your problem with the prior art an anticipation or a 102 issue or an obviousness issue? I'd be less worried if it was an obviousness issue. And then again, if you're looking at your competitors or any prior art as you're developing a product, if you're talking about a patent application that was ultimately abandoned, it doesn't matter. Okay, it's a published document, whether it becomes abandoned from a patent perspective or not. Okay. Oh, I see a question. If I can pull it up. Okay, yeah, no, I'm aware. 5 minutes left. So probably the last slide for our purposes will be public disclosure. Okay, so public disclosure of your invention, I'll just say this for now, pretty much destroys your patent rights. In the US, you have a grace period of 1 year. And there are some other countries that have other grace periods, Canada, China, or I'm sorry, Japan, but Japan's is very, very narrow. Somebody has to have like knocked you on the head and ripped it out of your hands and disclosed it. This is a concept that the Europeans call absolute novelty. So even if you just publish your paper, right, your patent rights are probably eviscerated in most of the countries of the rest of the world. So that's important. What is public disclosure? Paper publication, presentation, you go to a conference, you have discussions with investors, and you know the law likes to scare you, and it'll say, you know, even a public disclosure to one person, right? Even a presentation of one person of ordinary skill in the art is a public disclosure. And you know, we get this all the time where it's presented internally at Hopkins. So long as all those people are Hopkins people, well, that's sort of within your own company, right? That's not really a public disclosure. And again, this is another thing that we could spend weeks on looking at cases and really teasing out every little part. And so what we usually do is we want to protect with a prior patent application filing. Okay, now that disclosure must be an enabling disclosure. Okay, so if, let's say I have a drug and I go to a conference and I just call my drug, you know, JHU1, and then I show my in vitro data, and then I show my mouse data, you know, cell line data, that sort of thing, and all I just say is JHU1, well, I haven't publicly disclosed the compound, right? So I'm okay. And again, it has to be an enabling disclosure. You know, if you disclose biomarkers and you don't tell them what the biomarker is, then that's not a public disclosure. Now, you could have someone sign a non-disclosure or a confidentiality agreement, but that's not really going to prevent them from stealing your idea, right? I mean, eventually you'd have to sue them, right, and battle that out. Or they could claim later that, you know what, we already thought of that before we even met with you. Okay, so the best way is to file a patent application before you publicly disclose. Now, if you talk to investors, they're probably not going to want to sign a CDA or anything like that. So you could try and keep it sort of an enabling, non-enabling discussion. Okay, so always keep in mind public disclosures of your inventions. I know I've worked with an inventor who I found out that his postdoc had posted an abstract on a blog. The inventor didn't know. Okay, and the grace period in the United States is a year. We found out like 368 days after that, after that posting, that it was made, and the whole thing was gone. So, like I said, I'm going to end right here because we're near time. Again, I'm going to send to Carrie this presentation. And again, feel free to email me if you want to talk a little bit more, you want to clarify anything. I'm available to discuss. Okay, so I'll stop there. I will open it up to questions if there are any.
Guido, can you go back? I think it was your second slide that had copyrights, patents, and trademarks and so forth. And can you talk about how software can be many of those, and how people should think about software patents in general and the best way to, I'll call it, maximize the value of software depending on which approach should be taken?
Sure. So there was a case about 20 years ago, a patent case that declared that software is patentable, and it created this rush of hundreds of thousands of patent applications being filed. About 10 years ago, a series of cases came out that really called into question the patentability of software and the function of that. So it's sort of a cloudy area now, but that doesn't mean you shouldn't do it. It depends on what the invention is. So you could protect your software, or at least it's worth talking to an attorney about whether you want to file a patent application on your software, okay, which takes a long time, by the way. At the same time, you could protect the code for the software by filing a copyright registration application, okay? Now, that is sort of somewhat limited protection because somebody could have the same idea. I think we said this before. Somebody could have the same idea and write different software and not ever refer to your protected code, and they wouldn't be a copyright infringer, okay? And again, at the same time, you could, if you're a big company, just build a lot of goodwill with a trademark for your software, okay? Which you could really only enforce against someone who has a similar or confusingly similar trademark. And then again, you could also just kind of keep this all secret. I guess the example I can think of off the top of my head would be for a diagnostic company, right, who may not be patenting their software that allows you to take all that expression data and figure out whether someone has a disease or not. Maybe they just keep that in-house, right? And you send them, the test results, and they calculate whether you have the disease or not, right? So Brian makes a really good point that each one of these types of intellectual property are not mutually exclusive, okay? And that you could build some good protection around the device itself or the software, the brand of it, maybe if it's software code, and maybe there's aspects of it that would be a trade secret. So that's a good question.
And if you go the patent or copyright route, do you actually have to publish all the lines of your code? What gets disclosed publicly?
Okay, so when you file the copyright registration application, you are supposed to submit a deposit to the Copyright Office of your code. Okay, now you can redact some of it. You don't have to do all of it. It depends on how big it is. You could do like the first 50 pages and the last 50 pages. And that is not public technically until it's registered. Copyright Office is a little bit different, right? They don't examine this stuff like trademark examiners and patent examiners do. They don't look at what's filed before. They just make sure you just kind of checked all the right boxes, you paid the fee, and then boom, you're registered. And once it's registered, it could be accessed by the public. if you have a court order, and there are other ways to get it. And then patents, of course, are published at some point. So yeah, you could be disclosing these things. And again, for the copyright and software, in a year, that whole thing could change, right? You could change your software in a month, in a week, and then what do you do with what you've already filed on? And there's sort of a mechanism in the Copyright Office to handle that, but it could be a lot of filings. Okay.
Any other questions?
Can I ask another question?
Ask. Yes, Jeff.
Okay. So the very last example where you were talking about the postdoc publishing his abstract somewhere online.
Yeah.
Why, if no one has actually patented that invention, whatever it was, why would they not be able to continue with it even though he disclosed it over a year ago?
If no one had patented it, okay. Well, it's a little different. Okay, so the government, the policy behind it is they want you to disclose your inventions, and if you file your patent application within a certain amount of time, you'll get that limited monopoly to exclude others, right? So you can't just disclose your invention and then later on file it, 2 years later, even if no one else filed on it. Okay, that has become part of the prior art and is novelty and obviousness defeating, unfortunately.
Okay, that makes sense.
And there could be aspect, if it is an abstract, I wouldn't necessarily, poo-poo everything, but it depends on what you describe. What did you disclose in there? If you didn't disclose the biomarker, then what's the problem, right? You didn't disclose the structure of the drug, then there's no problem. It's not a public disclosure of that invention. But don't publicly disclose.
Okay, and I have another question, and it might be kind of a naive question, but it seems like there's all these fail-safes to patenting inventions or anything that, is already prior art or, comprised of within the prior art. So how is it that, there's so many, like we have to check it and disclose prior art, and then you have someone at the USPTO, double checking your work. How is it that there's so many, cases of litigation out there, or with people infringing on other people? Like how is that happening? Like, do other pharmaceutical companies just like make a molecule that they think is not comprised in a prior art, but the other pharmaceutical company decides no, that is, and they just try to like battle it out? Or
right. Yeah. So let's say that your competitor, you're always going to say that your competitor's patent is invalid because it's not novel or that it's obvious, right? You may not necessarily have that information on hand, but that's always going to be your defense. In terms of prior art, yes, we have, the patent owner has that duty to disclose the prior art. The patent examiner is going to do his or her own prior art search, but still, you might not uncover all that relevant prior art. You don't have a duty to look, right, as the applicant or the patenter. You don't have a duty to look, but if you look and you find, then you must disclose. And there may be old prior art that you're just not aware of. Maybe a patent application that is written sort of in another field, but maybe there's disclosure in there somewhere that applies it to your field, right? So the inventor may not be familiar with the inventors on that patent application because it's sort of a different field, but there's a lot of prior art out there, and defendants in litigations will find prior art. Don't you worry.
Okay,